No one gets everything they want in a settlement agreement. Now that you have your legal partner, you and your legal partner have trust with each other, and you have processed all of the information necessary for your case, it's now time to go to the negotiation table. The purpose of going to the negotiation table is to reach that final agreement that will resolve your case in its entirety. The negotiation table can take on many forms. It can be mediation, attorney-assisted mediation, or the collaborative process. In the collaborative process, the parties hire a team of professionals, including divorce coaches and other expert neutrals in addition to their attorneys. They also sign a collaborative participation agreement and use the team to help navigate them through resolving their issues. During the negotiation, inevitably what will happen is both parties will take their positions on various issues. In a mediation, the mediator is trying to bring the parties closer together based upon the different alternatives that the parties have laid out and their goals and concerns. Oftentimes, the parties enter into dispute resolution because they think the process will be easier. It is definitely easier and less protracted than court, but that doesn't mean the issues aren't difficult and that there won't be some difficulty in reaching an agreement. You can expect at a mediation, sometimes things start off very slowly. Parties are reluctant to put forth their best position until later in the day. The mediator may keep everyone together for a period of time, or he or she may ask the parties and their attorneys to separate so he or she can go back and forth and talk to each one and assess where each party's real final position is. It is not uncommon for parties to reach an impasse in both the collaborative process and mediation. This does not mean that the parties should stop negotiating or talking. It simply means that either the mediator or the collaborative professionals need to reframe the conversation or move the conversation in a different direction. When parties reach an impasse, there's a couple of things that the professionals leading the negotiation can do. One of the common things is talking about ranges with the parties. This could be ranges for a lot of different scenarios. It could be a range for a property settlement division, a range for child support, for alimony, or even parenting time schedules. The reason that lawyers often talk in ranges with their clients is because in a mediation or the collaborative process, it is impossible to give the clients with pinpoint precision the actual amount that a judge would order at a trial. It is, however, possible for the attorneys to give the parties ranges. So it is important for the clients to understand when they are in the middle of the negotiation if they are at the point where both parties are within the range a court would order. If they are, it is very possible that an agreement will be reached. When working through an impasse, oftentimes clients will ask their attorneys, should I just give up and go to court? The answer to that question is, it depends. If the negotiation is yielding results, which your lawyer is telling you is likely very close to what you could achieve in court, then you probably should continue on. If, on the other hand, the negotiations are going in a direction that is inconsistent with what you may receive from a judge in court, you may want to consider that option. But it should only be after thoroughly vetting out all of the possible outcomes in court with your lawyer and understanding the costs that will be associated in going to court. Going to court may not be exactly what you think it is. Court is not LA law, it's not the practice, and it is not the courtroom scenes that most people have seen in the movies and on television. The judges presiding over family law cases have a tremendous amount of work on their docket. They also don't have the ability to listen to the client's story the way a mediator or an attorney in a collaborative case can listen to the client tell their story without the restrictions of the rules of evidence. Also, the judges are confined and must rule according to the law. They don't have the ability at a trial to be creative or order anything that the law does not permit them to. Unlike in a mediation or in a collaborative case, the professionals can work with the parties to craft a creative solution that may be outside the limits of the statute. The Illinois divorce statute has very strict guidelines with respect to the calculation of child support and alimony in certain circumstances. A judge will be required to follow those guidelines. However, in a mediation or a collaborative case, the family can look and decide if an alternative approach is better. In a dispute resolution setting, the professionals can look at the particular facts and circumstances of the family and decide whether an alternative arrangement would be appropriate. Unlike court, a negotiation with the proper professionals, with the proper education and advice, can often break open creative solutions that the parties did not think possible at the beginning of the negotiation. Sometimes the dispute resolution process can take longer than the parties want it to. They can feel frustrated and stop believing in the process because they aren't reaching agreements quickly. But if they keep talking and stay at it, you could be surprised at some of the creative solutions that break open just before everyone is getting ready to walk away from the table. Follow me on LinkedIn or visit my website for insight on finding your legal partner.